It's time for another visit with Marshall Chriswell, and this radio program is intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date in your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And Marshall Chriswell is on the line with us for another installment of Marshall Law. Marshall, good morning.
Good morning.
How are you?
I'm doing well. How are you?
Wonderful, wonderful.
Good.
All right, so the disclaimer I just read talked about different jurisdictions have different laws and regulations, and this topic seems really built for that sort of a disjoiner because I want to talk about DNA tests, home DNA tests, and how they can have an effect on different cases that you might handle as an attorney. I'm thinking particularly of probate cases. So take it from there.
Okay, sure. So home DNA tests have, I think most people know, have become really, really prevalent over the past few years. I think it's a multi-billion-dollar business. There are these big companies, I think 23andMe and Ancestry.com. They have these home DNA tests where you can get all sorts of information because these things have become so prevalent. That they have created these massive databases of genetic information, and so you do one of these at-home DNA tests, and you can find out all sorts of things about your family and who you're related to, and your heritage and things like that. And it's affected the legal world in several ways. Now, we used to just think of DNA tests in the context of criminal cases, and then paternity and family cases, things like that. Mm-hmm. But it's really affecting, as you mentioned, probate estates. So, you can get this information through these at-home tests, and all of a sudden you're finding out. People are finding out family secrets, things that they otherwise wouldn't have. So maybe you find out that you have a sibling that you didn't know about, or maybe you find out that your brother or sister is actually only your half brother or sister. Mm-hmm. And in a lot of cases, folks are finding out that their one or more of their biological parents are not maybe who they thought they were. Mm-hmm. So it affects a probate estate in the fact that under Pennsylvania law, like most states, when someone passes away without a will, if it's an intestate estate, then what does Pennsylvania law say? It says that your heirs at law are entitled to inherit your estate in certain fractional shares, depending on how many of them there are and what relation to you. And so if you have folks that are previously unknown heirs of yours, mm-hmm. that can come out of the woodwork at the time of prior to the distribution of your probate estate, then your assets, your estate, is not going to go entirely to where you thought it was going to go, not to where you intend. So you're seeing all sorts of interesting situations.
You placed particular emphasis on the phrase heirs at law.
Right.
Yeah, and that would seem to be either something that opens a door or maybe closes a door, would it not?
Sure. And DNA testing is very useful to determine whether someone is an heir. If you pass away in Pennsylvania, the intestacy laws, what it says, if you pass away without a will, then if you're married, then everything goes to your spouse. If you're married with children, then there is a division between the spouse and your children, and it depends on whether they're children from that marriage or from a prior marriage. But and then down the line, if you don't have a spouse or children, your estate goes to your parents, and then your siblings, and down the line. So those are your heirs at law, and it depends on who survives you and in what numbers, what the fraction is. But the more of them there are, the less that each heir is going to receive.
Mm-hmm. Yeah, that pie gets sliced up a little bit more, which really makes it incumbent upon anybody to get to their attorney and make sure that the dispensation of their estate is done in the way that they want it to be done.
Right, and the prevalence of this DNA testing and the fact that we know, because so many people are doing this. I mean, there's going to be there's almost going to be a genetic map of the entire world here soon.
Yeah.
And so it's really affecting the way that we're drafting trusts and wills to ensure that in the event this is what the client wants, that prior unknown heirs are going to be essentially disinherited, because you just don't know. There are a lot of folks out there that have children that they're not aware of,
yeah.
and it pops up. So we want to make sure. And the other thing is, whenever you meet with an attorney and you're planning to do wills or trusts and those types of documents, I always ask my clients, if I'm talking to, let's say, a married couple, and we say, okay, well, you've provided me this information regarding your two children. Do either of you have any other children, or the possibility that there are any other children? Whether they were adopted adopted out or
mm-hmm.
something. Is there any possibility there are other biological children out there? And it's very important to be honest and upfront with the lawyer about that. I've had that situation where I asked that question and met with uncomfortable silence from one or both of the clients, and it's important to be upfront about it, because we need to figure out what your goals are in that respect and make sure to draft the documents accordingly.
Yeah, I'm sure that sometimes families find out without having any prior knowledge too that there was another child involved, and it's a shock. Talk about challenges to the DNA tests. I'm sure that has to be a part of this, does it not?
Well, the DNA tests can be court-ordered, and so somebody comes and says, well, I took a DNA test and these are my results, then it's good evidence, but it does have to be, you would need to, if you were going to mount a challenge to that, to have, an opposing expert witness say, well, the DNA test that was taken shows a 75% match of DNA or a 65% match of DNA with this person to be a sibling or something, and so they're not always foolproof. And you can have another expert come in, review that report from the company, that the DNA company, and you can challenge it. Now, sometimes with a child, when you're talking about a child or even a grandchild, the results, if it's positive, are generally 99.99998%. It's very difficult to challenge those. But when you're talking about siblings and half siblings and things like that, it gets a little bit more murky sometimes.
Are Pennsylvania's laws substantially different from other states and what they do?
I think that most Pennsylvania law does not directly address, the statutes don't directly address DNA testing and the concept of probate. It takes, and I think we've talked about this before, when you're talking about legislation, it seems like the legislation is almost always, about a decade behind the curve when it comes to technology and things. It's not specifically addressed, but every state does address, I believe, what happens when a previously unknown heir is found, and the time frames that they have to make a claim, and what their share is. And also, and I know Pennsylvania law addresses what's called pretermitted children. Pretermitted children are children that are born after you make your will. So if you make a will, you say, all right, I want everything to go to my only child, Johnny, and a few years later you have another child, Nancy, but you don't put her in the will. The pretermitted children statute generally operates to include Nancy in the will as your biological child. Mm-hmm. Now, there are cases where you may have a child later that you didn't know about. After Johnny, you think, and then you have another child that you're not aware exists. Then the pretermitted children statute actually makes them included as a part of your will. But we can include language in the will that says, unknown children are disinherited. So, but it gets complicated.
Yeah, I would guess. And I would guess as well that people who already have their will made out and think that they have that all sewn up the way that they want it to be might have a few questions now about whether they need to make certain of things. And so that would say to me, if I were in that position, I better call my attorney now and make sure that every I is dotted and every T is crossed.
Right. Yeah. If you don't have a will, this is just one more reason, and we've discussed multitudes of reasons on this program to have a will. So if you don't have a will, this is just one more reason to do it. If you do have a will, there's it's a good idea to have the language reviewed and just see if we need to tighten that up at all regarding unknown heirs. But yeah, and as I always say, I recommend having, if you have an estate plan, you have a will, you have a trust, you have powers of attorney, at a minimum, once every 3 years, have an attorney put their eyes on it and give you some advice as to whether you need any updates to keep it current.
I'm just interested in all you attorneys sitting around the attorney clubhouse and saying to yourselves, okay, here's the hot issue today. How hot of an issue is this among your colleagues?
It is. I'm involved in some lists, some attorney conversations online, forums, listservs that on a national level, and this is an issue that's been coming up over and over. That's affecting affecting legal cases, particularly these estates. So it's only going to become more of an interesting issue for us as we move forward.
By the way, where is that clubhouse? I'm just kidding. But where is your clubhouse? If people want to get in touch with you, talk about this or any other legal issue, what need they to do?
Well, you can come over and see us in the R&P Cole building on Church Street in Indiana. We just got some new signs up finally here at the new office so people can actually navigate the building and find us now, so that's good. And you can go, you can call me at 724-465-5826 or go online to www.westernpalawyer.com.
He is Marshall Chriswell. Thanks so much.
Thanks, Todd. Take care.
You too. Have a great day.
You too.
Have a great day.
You too.
Have a great